ladies and gentlemen. Is this thing on?
Yes.
Welcome. We are here to declare independence from the oppressive and malicious British, and we hold these truths to be self-evident. Our new country will have new rules, and in 13 years or so, we will ratify a new constitution. We will not be a monarchy ruled by a king. We will instead be our own country with our own traditions, our own laws. Here on the 4th of July, 1776, we declare our independence. Our scene is set on July 5, 1776, where upon the declaring of our nation's independence, our forebears now have to figure out what that means in court.
Hear ye, the Supreme Court of New Hampshire comes to order on this July 5th, 1776.
What were you all talking about? It was so loud in my chambers I could hardly focus on my crossword puzzle.
Your Honor, we have declared independence from England. Have you not heard?
The news arrived this morning.
We have?
I was woken at 6 o'clock by the people yelling in the street.
I found out at 7 when I arrived at my office.
6, 7.
My kids kept saying it. It's awful.
It has no riz.
It's not fun. When I was growing up, we had sayings and they had meaning. And jokes actually made sense. It doesn't even have any meaning.
Hello, everyone.
Hello,
Lord Cornholio. That's right. It is I, Lord Cornholio, and I need...
We know what you need. We don't need to hear it.
Did you hear the news? We declared our independence from England.
Independence from England? Oh, please. You're more likely to see the inside of the new courthouse.
Right, the courthouse is on schedule and it always has been.
Don't change the subject, Lord Cornholio.
You shouldn't be so smug.
You're officially a trespasser in our new nation.
Trespasser, how dare you? In fact, resistance is futile. I'm going to tell you something. There's no way you people can possibly win this war unless I suppose hypothetically you ended up in a very good war of attrition, you had the right people, and eventually France joined you. But what's the chance of that happening? None. We will continue to kill you for 7 years and, let's say, 1 month and 28 days, and then maybe we'll give up.
That seems oddly specific, but fair, I suppose. But I have one question. What laws will be followed then?
Don't we have a bunch of state laws?
Yes, of course, but what if I need to interpret those state laws?
If only there was some sort of law which was common to all of you common colonials.
Oh, come on, that's not something you would do often, right?
Hey, Cornhole, in light of the Declaration and our independence, I think I have something for you. I won't be eating this anymore. I'm sure you know where to shove it.
How dare you? As my good friend Prince Andrew has said several times to his very good friend Jeffrey Epstein, I'll see you again soon.
All right, that's the end of scene 1. Let's put ourselves historically back in this time and remind ourselves what was the state of the law in the 13 colonies that were brash enough to declare independence from Mother England. Anybody want to comment on that? How did they govern themselves civilly and criminally in the 13 colonies in those years? Well, they had charters. Each of the individual colonies had a charter. They had some independence from one another. There wasn't much clarity on how the colonies interacted with each other. But in the end, the King George III had the final vote. He had the veto on all of it, and they were subject to the monarchy. Because of that, you know the rest of the more common part of the story, that that's what led to the commoners here in the colonies deciding that they would declare their independence. Having done that, however, the big question arises is how would they govern themselves after that point? And so let's think about that for a minute. If we were trying to put a new country together and have a system of laws, what were the options that they had available to them in how to govern themselves, having declared independence from their prior system? Anybody given any thought to that? Yes, sir.
They
Mr.
used the
Dennis.
exact same system. The problem was that they weren't getting representation in the current government. They already had all the rules, so they just wanted to say, we'll keep what we have, but we just need them applied to us.
Okay, so we were sick of the king, we were sick of the bowing and curtsying, we were sick of boiled potatoes, we were sick of all the things that the British imposed upon us, many of the things, but we had to make a decision on how we governed ourselves going forward. Now, there were other options. They could have started from scratch. They could have made a determination that they were going to adopt somebody else's system. France had a pretty decent system of laws at the time. They could have reverted back to a theocracy of some sort. There are various things that could have been done, but they were smart enough to recognize, let's keep what is working and not throw the whole thing out. So, the common law. Anybody want to talk about what benefits of the common law would be? Why would it have been beneficial for them to carry on with that same system when they were throwing so many other British things overboard?
Less work, you don't have to write new laws.
Yeah. If it's not broke, don't fix it. Carry on.
Property ownership.
What do you mean by that?
Common law, I mean, like, that's what most of the law is about ownership of things. So if you keep the same law of common law, then the ownership would be continuous. And ownership's a big deal if you're talking about settling a new land. Ownership of land, ownership, how you would possess that land.
Very good.
I would think there's also something common law kind of, I believe, would support. There's a natural law, there's a higher law. That legislation can't just be created that's going to violate those types of tenets. So common law gives you protection from the legislative branch from just coming up with new laws or different laws.
Yeah, and we're going to spend a little more time on that in a minute. In your colonial times, I hope you'll all take a moment to read that. One of the quotes there says, Thomas Jefferson has admitted that the Declaration of Independence had no original ideas, but was instead a statement of sentiments which were shared by supporters of the American Revolution. So, they declared independence and said they were going to be in charge, but, then what are the next steps forward? And to hang on to the common law obviously was a good thing. Skip number 2.
Following the case of Pearson versus Bose.
Will the parties please step forward to address the court?
Your Honor, I come before you today aggrieved.
Not as aggrieved as I am.
And I'm back. Hello again, friends. I am here to represent the most important part, the most honorable part of British culture.
What?
The fox hunt. Do you think I was going to talk about dentistry?
Why are you here?
You lost the war.
That's kind of up for debate. We can do without South Carolina. But what I am going to say is this. In 200 years, I will wager that England will be stronger than ever.
All right, great. These people trespassed on my land.
Treacherous falsehood. We were pursuing a fox, as is our rights.
I saw no such thing. There's a fox on my land.
But it is a fox, a wild creature. It belonged to the wealthy people who were pursuing it.
It was on my land. It belongs to no one because it is a wild animal until it's killed by me.
But I have the strongest claim. It was dastardly, and I'm pretty sure it insulted my family.
All right. All right, you're dead, you know.
Come to me, Fox.
So what do we do?
Okay, so.
Oh, look, he's trying to come up with a decision. Eventually, he might be actually ready, like our new courthouse.
The courthouse was only slightly delayed due to unexpected inflation and cost overruns.
So am I getting my Fox?
Or do you agree with my right to an animal on my own land?
Well, let's see, as the 6th century Justinian code says.
No.
How about the 13th century cleric Henry de Brockton?
Nerd.
I guess I have no choice but to rely on.
That's right. Who's your imperial daddy?
Common law. Based on all the evidence I've heard today, and while a whole bunch of other stuff that I'm pretty sure I learned in law school, Pearson wins.
Let's.
Yes.
He killed the fox, and it's a wild animal, and whoever kills it gets it.
Victory.
And see.
Very good. Pearson versus Post, anybody remember that one in law school? Pearson probably was motivated, as he is, we've seen enough movies, he's trotting through the woods with his whole entourage in the middle of a fox hunt. And Post comes along, seeing that the landed gentry, the higher class of folks, was in pursuit of this fox. I've got him turned around, and then he shoots the fox, and there arises the debate as to who was the rightful owner of it, he who was in pursuit or who actually killed it. And so this case was of some interest in determining property right laws, and was probably motivated by the fact that the wealthy person was indignant that a commoner was there, allowed to shoot and keep a fox. So it probably had as much to do with socioeconomic status as anything else. But if we are utilizing the common law as we move forward in the Revolutionary period, there are a number of cases that continue to be affected by that even in the current times. For example, some of you might have heard of the Dobbs decision, reversing the abortion ban. This person that they were demeaning in the presentation in the skit, Henry de Bracton, was cited there as for the proposition that abortion is not historically a protected right. So it's been hundreds of years since we parted company with the Brits and have developed our own rules, but there are still many cases where the English common law is cited. Another one, U.S. versus Jones in 2012, quoted one of the landmark British cases called Utic versus Carrington, clear back from 1765. This was a search and seizure kind of a case. Some of you who work in the criminal realm might know more about it than I, but it talked about what constitutes a physical search and what constitutes a trespass. And they called this case, they quoted from the British common law, a monument of English freedom. And so it's who is our imperial daddy? And we do literally continue to have involvement in those cases even now. Now, besides the common law, of course, we have legislatures who are passing statutes. How many new laws come out of Sacramento every year? Probably more than we care to know about. But in this, there's the competition between whether laws should be passed by the legislature and become statutory, or whether we should rely on the common law as it has continued to develop in our own system. I thought it would be interesting if we maybe split up into two groups for a minute, and we have one group that tells us the benefits of the statutory scheme and laws passed by the legislature as opposed to laws that are developed through judges in the common law. So why don't we split it sort of right down the middle? This table, Judge Maines, and Nicole's table over to there. You will be the statutory scheme, and you other three tables. Here, Catherine Green's table, the one in the back, and over here, Mr. Goss, you will be the common law. So you were just talk amongst yourselves, and the question is it preferable to have the common law? What are the advantages of it, and what are the advantages of legislatively passed statutes? You'll have just a few minutes. Ready, set, go.
Okay.
Somebody who's from one of the tables for promoting the benefits of the common law over legislative would like to speak. Go ahead, let's hear from you. Who's your spokesperson, Ben?
While you're asking me, I think it's your role to pick on somebody, Matt, since you're around the whole discussion.
Mr. Johnson, what was the discussion?
I think the general discussion was the benefits of having elected representatives that are drafting the laws, as opposed to these elite judges that may or may not be in touch with what's actually happening. I'm talking about appellate judges, to be clear. Nobody that's here.
Well, correct. In our system of laws, the published decisions obviously are coming out of the Fifth and the Third and the State Supreme Court as opposed to Department 21. But it's all a part of the process. So.
One of the other things that was mentioned was adaptability. The legislature can move a little bit more quickly if there's an issue that maybe hasn't been considered by the courts yet. They can pass a law so that there's guidance on an issue that hasn't been considered.
Flexibility. Okay. Any other things in favor of the legislature acting as opposed to judges determining the law? Any others?
Too many gaps between the judicial decisions. You've got to find something to kind of fill the framework up. Not every issue has been considered by a court yet.
Okay, what about the rear tables? Did you have any insights?
I didn't.
Additional thoughts?
Yeah, great point. Yeah.
So some of the things that were mentioned as pros for the legislative process, we actually found pros for the judicial process, and that it doesn't move as quickly and it doesn't shift as fast, and it's not as tied to political whims, and that provides some stability and reliability, continuity, groundedness, some things that judicial officers who are further removed from the whims of the people would be able to protect the people from themselves, and we see that as a pro for the judicial process.
We like that if the Supreme Court justices at the time are ruling the way we like it.
Don't know. Don't really know.
One of the issues against the legislative,
Go ahead.
Against the legislative aspect of creating laws is most of our elected officials are, I'll just say it, they're owned by the people that have put up the money to put them in power. And what happens with the judiciary, you have people that are actually taking into consideration everyone's potential outcomes, the good for all versus the good for some. And I think we have too much money and too much influence making the laws, and the people that don't have that money or the influence are almost always on the outs. And so the judiciary can use that discretion to look at the overall picture of how it affects everyone versus the person that, for example, may want to change the tax laws to benefit someone that's a billionaire and putting the onus on people who are just barely getting by.
In the back.
One thing that came up quickly at our table was accessibility for the public. Common law requires lawyers and lots of interpretation. The legislation tends to be a little more, hope that it's a little more straightforward and accessible to the public.
Yeah, have you you read those laws? No, your point is very well taken. It's more defined, more accessible to the common person as opposed to having to do all the research and see what the case law would be on a given point. Okay, very good. Are we ready for scene 3? Our next scene is from 1 year later, 1806, where questions of when common law applies still abound.
You're blocking the video.
Okay, people be Hudson, Goodwin, council.
Dorian Morgendorfer for the people.
Stuart Stevenson for Missouri, Hudson and Goodwin.
Okay, Mr. Hudson, Mr. Goodwin, you are charged with seditious libel for your newspaper article.
That's right, Judge. Their actions in this case are nothing more than shocking.
Oh? What did the accused actually do?
They are nasty people, and they printed fake news about our president.
Mr. Hudson?
Well, we did say that Jefferson paid $2 million to Napoleon so that the U.S. could buy Florida from Spain. And I mean, that might have been true, or I suppose people could say that we maliciously made it up.
Wait, seriously?
Fake news. I don't understand. Is that even a crime?
Well, we had the Sedition Act. It expired 5 years ago. You can't just charge people with crime without a code section.
Hello again, friends.
Ah, you again. Why are you back?
I'm here to tell you that sedition is actually a crime, and so is libel in common law.
What?
That's right. You cannot, in common law, libel or slander people. For example, do you know, people are saying the nastiest things about my good friend Prince Andrew, who actually, just like everyone else, loves island vacations. But here's the thing, I can tell you with confidence, he will end up on top. Something tells me there'll be a sequel to that in about 1812.
But wait, hold on. That's the entire case? These guys were prosecuted for basically LBJ conspired with the CIA to kill JFK?
It is fake news, and these are nasty people. Everyone knows that. Everyone is saying it. These are low IQ people.
So you charge them with a crime without there being an actual crime in the book?
Well, yes.
Okay, well, I guess it's common law, so I'm going to say that's perfectly cool.
That's right, perfectly cool. England wins again.
Jefferson paid you.
You're in contempt.
Oh, there's no law that says you can hold me in contempt.
You're fined $15.
How do you think the Supreme Court's going to take this?
It'll take them 7 years.
7 years, you say? Sounds like just enough time to build about half a courthouse.
Hey! Badly suspicious libel will make clear I can hold people in contempt without a statute. Otherwise, Congress has to pass a law.
All right, let's talk about that for a minute. The case is U.S. versus Hudson and Goodwin. I found it interesting that many years ago, in the early 1800s, that somebody was being charged with seditious libel, saying that politicians would conspire to pay $2 million on the sly for Napoleon to take some action with Spain. The point of the case is that the particular act had expired a number of years prior, and so there was no law that they were trying to be charged with, and so the court didn't have jurisdiction. There wasn't a federal law for them to be charged with. So, under the circumstances, as it occurs presently, to be charged with anything federally, it has to be a statute, and common law doesn't apply in that scheme. But little research on it showed that there are still 14 states that have allowed you to charge someone just based on a common law offense without there being a statute. Florida, Mississippi, a whole bunch of other ones. You who work in the criminal arena, what role do the cases in common law play in your work? You're not charging somebody for a violation of a crime that's only listed in the common law. How do those cases figure into your practice?
I've never had anyone arrested under one, so they don't figure in at all.
Are they utilized for describing some of the elements of the crime? Or you telling me you do no research in the common law whatsoever? Only for evidentiary matters?
Yeah, basically.
Well, a lot of the crimes are statutory, the common law made it into statute. So larceny, burglary, murder. So I suppose there are common law cases out there. If there's a question of whether an element is met, maybe those cases might be consulted, but I can't say that I'm aware of any that have come up in my department.
It says that the state of California prohibits common law to be charged under it, but you it can't help but find certain of the statutory elements. Doesn't sound like it's very common here. Okay.
My daytime burglars, they all go home.
Actually, murder, does have a lot of common law to it, what is murder? I mean, we've got the basic definition under 187, but then whether you're a major participant who acts with reckless indifference comes from case law and all of that, and which kind of murder, felony murder, and that kind of thing. So the statute defines it, but then case law is defined what that means and who would still be guilty of murder based on what case law holds.
And then the statute, the legislature redefines it, and we do it all again.
And again.
And again, and again.
But they didn't, they redefined what malice meant, but they didn't redefine what those basic things are. So it comes from case law. So that's one good example of what comes from case law. Judge knows.
Okay. Let's return just for a second to what application the English common law has in any cases of any significance, say, in the last decade or so in the United States. Some research was done on this, and let's take, for example, the 2024 decision of Trump versus United States. We're not looking for the tables to be turned over or there to be any kind of riot here today. But you remember that's the one that they spoke of broad presidential immunity. For core actions, it was absolute. For official actions, there was some presumption of, and then unofficial actions was going to be bumped down to the lower courts to determine. In that particular case, they did reflect the English common law talked about, overthrowing broad monarchical powers, and they quoted the English common law in that decision. I'm not sure they reached the right decision. There's another one, Trump versus Casa. You may remember this one when he first got going. A federal district court judge in a particular venue would pass an injunction and say it couldn't be done nationwide. You remember that case? That was 2025. Whether the federal courts can issue a nationwide injunction, and they quoted the English common law on that and said that the English equity courts said that you can't grant relief to parties that are not directly involved in the suit. So those were just some applications that have occurred more recently. If we turn to the state of California, the California Civil Code, I found this to be interesting. Section 22.2, common law is a rule of decision. The common law of England, so far as it is not repugnant or inconsistent with the Constitution of the United States, the Constitution and laws of this state, is the rule of decision in all courts of the state. So On holy oath stands. We're going to try something here in conclusion that's never been tried before at the ends, as far as I recall it. Judge Maine has written lyrics, somewhat AI assisted, and Ramson has put it to music. It's as schmaltzy and cheesy as you can imagine. But the words are going to be up on the screen, and we're going to sing it. And as moved by the Spirit, we want you to join in.
The words are also on the brochure.
Yeah.
Really loud.
There's a weight upon our shoulders, every tax the crown demands. We are all getting older, and these should be our lands. But the laws are currently from London, farther than Sacramento or Turlock. We'd like them to be in Washington, and not just to rule ad hoc.
We need to ditch the British, but we need to have some laws.
If we give up all the common law,
well, doing that would give us pause.
The king declares us subjects, and the law is what he says. to being objects, but we need more law, not less.
We'll build our courts on common law, on the old rules we'll rely,
but we'll also write our own statutes
to be American as apple pie.
The common law is a part of history, and it's worked for us so far. We cannot survive on a king's decree, because that's not who we are.